I see people are entering the room already. I've started a minute early, and you're probably wondering why I am speaking to you from the Mandarin Oriental in Bangkok, because if all goes well, in exactly a week's time, I will be standing in exactly this position, sipping my Singapore sling. That is, of course, unless the government has any alternative plans for me for what I should be doing this Christmas and New Year. And I just don't know what's going to happen on that front. But anyway, let's keep the politics out of contract law, as they say. I see people are still joining, so let me change to a more conventional background. Or there isn't one actually, so I'll keep this background on for the moment and go forwards. Okay, so welcome to everyone who's joined. Whilst people are still joining, let me just introduce myself quickly. My name is Richard Stevens. I am a commercial solicitor. I work mostly in the area of IT, and I work as LORS, L-O-R-S, the Law Office of Richard Stevens, so I help you get the right IT contract in place. I also work as a mediator and arbitrator in the world of IT mostly, and also provide training in commercial law subjects. I'm a lawyer, as you can tell, so I'm going to start with some caveats. I'm a lawyer, so I have to. I'm an English lawyer. I know some of you are joining from abroad, so I'm talking about English law. So, of course, your legal system may be different. Of course, English law is used in any international contracts, so it's still relevant to that extent. But just bear in mind, I'm talking about English law. The other point is this, that all contracts are applied by judges in particular circumstances. So if you've got a particular situation in mind, all I'm doing is just talking about the general law. Always get professional advice. So without further ado, let me share my slides with you. And so you should see my slides in front of you, which you now can. So let's start the timer and let's go. Law before lunch. It's all about delivering as much as I possibly can, as much value as I can, trying to keep it to 20 minutes, absolute maximum. Law before lunch, we're all busy people. And I know we've got an international audience, so it could be law before breakfast or law before dinner. I've called this one The End is Nigh because we're coming up to the end of the year. So it seemed appropriate to talk about termination. And in this case, to focus on termination for material breach. What exactly is a material breach? Well, we'll look at that in just a minute. Let's remember that there is this clause that goes normally towards the end of a contract that says that one or other party can terminate for the other's material breach. But let's not forget that English law gives a completely different right to the parties to terminate for the other's repudiatory breach, as it's called. I'm not going to be looking in detail at repudiatory breach. There have been many, many, many different ways of defining it. It's a breach that goes to the root of the contract. It's a breach that deprives one party of substantially the whole benefit it was anticipated he would receive from the contract. It's a really desperately serious breach of contract that in practice is very difficult to show. And that may be one reason why parties and their lawyers put in this little material breach clause. Now, given the ubiquity of the provision for material breach and termination, you'd expect there to be a list of cases as long as your arm or longer, with the judges telling us exactly what a material breach was. But if that's your expectation, be prepared to be disappointed, because there isn't. There are obviously some cases looking at it. Let's take a look at this one. Schuler and Wickman Tools. This was a distribution agency agreement. Wickman Tools undertook an obligation to make a specified number of sales visits to specified sales prospects at specified intervals. January to June in '64, they should have made 144 visits. They only made 125. July to October of that same year, they should have made 96 visits, but they only made 87. And the arbitrator found that these were not material breaches. It wasn't a material breach. And Lord Morris commented in the House of Lords, that finding of fact has not been, and I think could not have been assailed, but there were some breaches. In other words, you can have this concept of the breach, but it's not necessarily a material breach. And the closest you can get to a definition came up recently in this case, this Mid-Essex against Compass Group. This, you may recall, is the case of the £50,000 tomato ketchup sachet, because Mid-Essex contracted with Compass to provide it with facilities management at 2 NHS hospitals, including, for our purposes, management of kitchens. And what actually happened was they found a one-day expired tomato ketchup sachet in the fridge. And what they did was to leverage the service credit regime so as to maximize the service credits to bring the price down. And so when they found this expired tomato ketchup sachet, they kept awarding failure points day after day until they had been formally notified that it had been removed from the fridge, which was many months later. So I think they attributed £50,000 to this one-day expired tomato ketchup sachet, or it may have been chocolate mousse. Anyway, the facts needn't bother us. One of the judges in the Court of Appeal said this: material breach connotes a breach of contract which is more than trivial, but need not be repudiatory. So in other words, if you've got repudiatory up here at 100%, material breach comes in somewhere below. But he doesn't say whether it comes at 90% or 80% or 70 or 60 or even 50%. And he went on to say this: termination for material breach has the drastic effect of allowing Compass to cancel a long-term contract on 1 month's notice. Having regard to the context of this provision, I think that material breach means a breach which is substantial. The breach must be a serious matter rather than a matter of little consequence. Now, the interesting thing is there, he's construing material breach in the context of a long-term relationship contract, a relational contract, if you like. And so what he's saying is that the construction to be given to material breach is going to be more stringent. It's going to be more stringent a test than perhaps the material breach when contained in a contract for a one-off transaction. That means, if this is the closest we get to a definition by the judges, it's not a very good definition, because it could mean absolutely anything depending on context. Notice that he said that material breach means a breach which is substantial. Sometimes lawyers strike out on their own and they do a bit of original thinking. Instead of saying material breach, they use a word like substantial breach. Does that mean the same? Well, the answer is it might. But just be aware of this one case, Crane and Wittenborg, where the lawyer had used this term substantial breach instead of material breach. And what the Court of Appeal in this case said was substantial was synonymous not with material, but with repudiatory. Remember, repudiatory is a much more serious level than material. So just saying substantial breach could be equated with repudiatory and not with material. So what if you just say, therefore, any breach or a breach of any obligation? So you just leave it open. You don't use material, you don't use substantial or any other word to qualify it. Well, it does come up. It came up in Rice and Great Yarmouth Borough Council. I don't think this case has ever been formally reported in any series of law reports, and yet it gets cited all the time. This was a contract whereby Mr. Rice, trading as the garden guardian, contracted with Great Yarmouth to look after its gardens and its seafronts and its bowling greens and its tennis courts and so on. And the contract provided that if he committed a breach of any of his obligations, a breach of any of his obligations, Great Yarmouth could terminate. And the judge said it would be nonsense if they could terminate for a trivial breach. And the Court of Appeal agreed with him when he said there's no hesitation in holding that the common sense interpretation should be imposed upon the strict words of the contract. A repudiatory breach or an accumulation of breaches that can as a whole be properly described as repudiatory are a precondition to termination. So in other words, if you just simply said nothing, again, the default position of the courts appears to be to snap back to this idea of having a breach being a repudiatory rather than this somewhat lesser level of material breach. So can you imply material? What if you have, as this one, Vivienne Westwood, obviously the famous fashion designer, and she, or rather her company, contracted with a landlord and signed a side letter with the landlord, providing that on any breach by her or her company, the landlord could terminate. And one of the questions in this case was whether you could imply the word material before breach. And the judge, I think it was Simon Fancourt QC, sitting as a judge of the High Court, he mused and chewed his food rather about what material would be and what was materiality. Materiality to what? And he recognized the problems that courts have when they have to deal with this terminology, material breach. And he decided in the end, effectively, that the term was so devoid of meaning and so vague that it couldn't actually be implied into the contract. So what have we learned so far? We use this expression, material breach, all the time. Some of us talk about substantial breach or even just any breach. But these aren't terms of art. They don't get a judicial definition anywhere. And we've seen that there is a risk in using a term like substantial breach or just referring to a breach or any breach, because unfortunately, the sort of default position of the courts is to go back to repudiatory breach rather than this lesser level of material breach. It's a very imprecise term, but we lawyers, we're like lemmings, we just follow each other and we keep using the term. And I'm afraid the bad news is it doesn't really mean anything particularly definite. Next to a material breach clause, and contained within the same wording even, you'll have this concept of the remediable breach, or this concept that you give notice, 14, 28, 30 days notice to remedy a breach if capable of remedy, if remediable. It raises the question of what these terms actually mean. Again, it's interesting, isn't it? These words, this concept in contracts, it's almost ubiquitous. And you'd expect there to be a list of cases as long as your arm or longer still. But there isn't. There really isn't. We saw an example of remedying in this case recently, Baines and Arundel Capital. This agreement may be terminated by either party. It's an entirely standard sort of material breach term. It then goes on to provide for giving 21 days notice for any breaches to be remedied. Mr. Baines was contracted to provide consultancy services in the financial services sector. The parties had fallen into dispute. Arundel gave notice of alleged breaches, required remedy within the 21 days. Mr. Baines, by his solicitor, responded saying that he would comply with the terms of the contract between them. But in fact, he did nothing, and he didn't even perform any further services. So after the 21 days, Arundel terminated the contract, and the Court of Appeal upheld that decision. The remedy, they said, was to provide the services, not to promise to do so. So what we get from this is an idea that where there is notice to remedy, and where a notice to remedy is served, fine words will butter no legal parsnips. It's not just a question of saying you will comply, but you actually have to comply. We talked, to begin with, of Schuler and Wickman Tools. This was the case where Wickman Tools had to make specified sales visits to specified sales prospects at specified intervals. The breaches were in the past. How do you remedy breaches that are in the past? And the dictum that gets trotted out every time is Lord Reed's dictum in this case. Obviously, as we've seen, they had failed to make certain sales visits. So if you gave notice of breach and required a remedy, it wasn't a question of saying, well, you made up extra visits in the future. What he said was to remedy in that case meant to put matters right for the future. So what was past, as long as you carried on performing according to the contractual terms, that would be the remedy. But, and it's a big but, and he said this, if the breach is something like disclosure of confidential information, basically the cat's out of the bag at that point, and it could not be said, he said, to be remedied by a promise not to do it again. Again, fine words will not butter any legal parsnips. So you can actually remedy past breaches by actually just doing the right thing going forward. But some breaches, once they're done, they simply can't be remedied. I started by talking about this difference between contractual and common law rights to terminate. One of the difficulties in the modern law is that the judges have been chewing the fat about what is the relationship between these two different rights to terminate. And that's especially true today because we lawyers have included so many more rights to terminate than we used to in the old days. Again, it's like indemnities, and in the old days when I started out, there was only one indemnity in a contract, and that was the IPR indemnity. Now every other clause is an indemnity. It's the same now. Termination clauses, there used to be just one material breach termination right or insolvency right. Now, there are numerous little rights to terminate. If you breach the service level in 3 consecutive months, then we have a right to terminate. Lots and lots of different rights to terminate. To what extent, if you provide a complete code for termination in your contract, could you be said to have ousted or displaced common law rights to terminate? Do they sit then alongside each other? Or maybe one has ousted the other? Interesting question. The case I wanted to talk about was this one, which came out very recently. Hasn't really done the rounds. There's no great new law in it, but it does illustrate the problem very, very well. This was a contract between Digital Capital and Genesis Mining. The mining had nothing to do with minerals. This was to do with mining of cryptocurrency. And the parties agreed that they would each do their respective bits, front office and back office, to set up a unified banking debit card system for the use of cryptocurrencies. There were delays on both sides, but Genesis, it appeared, ran out of money. The judge noted that cryptocurrency shortly before that had crashed by about 75%, which jeopardized the whole project. And so Genesis, as I say, stopped paying Digital, and then suddenly out of the blue, Genesis lawyers wrote to Digital alleging irremediable breaches and also repudiatory breaches by Digital, and without giving any notice whatsoever, they terminated with immediate effect. And of course, when that happens, remember that if you purport to terminate a contract without having the right to do so, that can also itself be a repudiatory breach. And so Digital bias lawyers accepted Genesis purported termination as itself repudiatory, and therefore discharging any future obligations under the contract. The material breach clause is in pretty standard format. It's exactly what you see in most contracts. It refers there to material breach, failure to remedy within 30 days after receipt of notice giving particulars of the breach, requiring remedy. It also had this preservation of rights. In 16.5, rights to terminate will be without prejudice to any other right or remedy of either party in respect of the breach concerned. And that's important. The judge, it was Julia Dias sitting as a deputy High Court judge, and she referred to the great case in this area. There's a number of them these days because it's an area of law that's being looked at quite a lot by the courts. It's being looked at quite a lot because we lawyers are putting in so many rights to terminate. And the case is Stocznia Gdynia against Gearbulk. This was a shipbuilding contract, and clause 10 provided for delay. At first, for minor delays, there were liquidated damages. And then when you got to a drop dead date, there was a right to terminate the whole contract given to the purchaser of the various vessels. Following egregious delay, the buyer terminated and claimed damages for its loss of bargain. Loss of bargain damages are only available as if you've terminated for repudiatory breach. So the question arose whether they had terminated according to a contractual right to do so, or whether they had terminated as for a repudiatory breach. And the shipbuilder argued that the contract was a complete code dealing with delay and termination for delay, and that had the effect of displacing the common law rights to terminate. And the Court of Appeal said it comes down to a question of construction in each case. If you give a party a right to terminate, it could be a contractual right to terminate, or depending on how you construe the clause, it could be an agreement that a particular breach is always to be treated as a repudiatory breach, and therefore, in that case, the two rights, the common law and the contractual rights, would meld, would fuse, as it were, into one, so that if you terminated, in this case for delay, it wasn't just exercising a contractual right to terminate, he was actually accepting the shipbuilders' breaches as repudiatory because the parties had already agreed in the contract that they would be treated as repudiatory. And that's the reading that the Court of Appeal went for in that case. And the deputy judge in this case took note of all of that. She told us helpfully that a repudiatory breach is always a material one, but a material breach is not necessarily repudiatory. So again, you've got repudiatory up here at 100%, but does material come in at 90% or 80 or 70 or 60 or whatever percent? And as we've seen, it's not capable to give that definition of it. But she looks through the clauses and it just comes down to a question, therefore, of construction. Clause 16.5 preserved each other party's other rights or remedies. So in other words, the common law rights to terminate existed alongside the contractual rights to terminate, which meant that if Digital had committed repudiatory breaches, Genesis could simply bypass clause 16 altogether. It didn't have to give any notice to remedy, and it could exercise a common law right to terminate. The difficulty was on the evidence. She found that the breaches alleged to have committed by Digital were not repudiatory, that they were all of them basically remediable within the 30 days. Therefore, notice would have had to be given. In reality, the breaches alleged could have been remedied within the 30 days. Therefore, simply giving an instantaneous termination as if there had been a repudiatory breach was unjustified and was itself a repudiatory breach by Genesis, which had been accepted effectively by Digital. If you're into Schadenfreude, you can look at this case. It's immensely long. The judge goes through a vast amount of detail. The important thing about it is this: if you write to terminate a contract alleging one ground and you make it very clear you're relying on one ground, in this case, they relied upon the right to terminate as on an insolvency event, you can't then go back retrospectively and say, well, on second thoughts, we would have terminated and we think we should have terminated for repudiatory breach, and we would therefore be entitled to our loss of bargain damages. Unfortunately, the lawyer that wrote that particular termination letter relied exclusively upon insolvency as the reason to terminate according to a specific clause in the contract, and it could not be construed as a termination for repudiatory breach. And so by a single simple stroke of the pen, that lawyer had completely kiboshed any chance on EE to claim loss of bargain damages. Well, my 20 minutes are up, and I think the one lesson I want to get across is at the top of that slide. Never ever terminate a contract, I think is one way of looking at it. And if you really want to terminate a contract, you've just got to get it absolutely spot on right. Repudiatory breach is really difficult to show. If you have any slightest suspicion that the breaches are in fact not repudiatory and might actually even be remediable, then go back to that termination clause, have a look at it in detail. And if you need to give notice, give the proper notice, the proper way, and give them that time as permitted in the contract, 14 days, 28, 30, 45 days, whatever it may be, and only then reconsider your position. For drafting people, for drafting purposes, we keep putting in these rights to terminate. Not enough thought goes into what we're saying. If you're saying you have a right to terminate for example, one of the things I typically see in IT contracts, if you breach the SLA the same way in 3 consecutive months, we have a right to terminate. Well, are you saying that that breach is to be deemed always and ever to be a repudiatory breach? Or are you saying this is a separate contractual right to terminate? Very often, people drafting contracts just don't make that clear. There's also a risk, of course. The more rights to terminate you put in, the more it starts to look like a complete code providing for termination in every possible event. And some of the judges have been saying that where that is the case, it might actually have the effect of displacing the common law rights to terminate. So that's what I was going to say. I didn't realize until I started putting these slides together that I'd bitten off slightly more than I could chew, because termination is a massive subject. And I've only looked one tiny area of it. There's a vast number of other cases I could have looked at. If you like what I did today, well, you can buy me a coffee, not obligatory. It's always nice if you do. Those Singapore slings at the Oriental do cost a lot of money, so perhaps you could buy me a Singapore sling instead of a coffee. For your diary, if you like what you've seen today, you probably already know that I do an annual update on the whole of contract law for the previous 12 months for the Society for Computers and Law. You can book following that link, or you can just Google for SCL annual update 8th and 15th February 2022, and you will get to the registration page. We had, I think, 300 people online from around the world listening last year. It's a runaway success, so you're all very welcome to that. Without further ado, I'll turn over to see if there are any questions that people have, that you are any burning questions. You might like to ask me, what are my chances of actually getting to Thailand? I mean, that's probably an interesting question in and of itself. And my wife and I are sort of anxiously looking at the news every day. Well, actually, we're not. It's just terrible, just looking at it. But there we are. Any questions on termination? Any questions on Thailand? Very happy to field questions on either. No questions? Any chat? Anybody want to? Oh, thank you, Marie-Louise. Thank you very much. Thank you, Alexia. Yeah, I know, Isabel. It's just terrible. I mean, I could actually. Do you know the last holiday I had was in? Do you know the holiday I had was in August 2019, and since then I haven't had a weekend off. I haven't been anywhere, or anything like that at all. I should say as well, obviously, to everyone here, happy Christmas if you celebrate it. Happy holidays if you don't. Have a great time. Yeah, thanks, Alex. You too. You and all your team. That'd be great. No questions. It's termination is just a huge area. Repudiatory breach is such a risky thing to do, and you have to be so certain of your ground, and you can be foot-faulted at any time. But I wasn't really looking at repudiatory breach this time. But a lot of lawyers think that just by putting in that material breach clause, they've made things really simple for themselves. Actually, it's like frying pan and fire. It's not that. It's not that straightforward. It's not that clear cut. There's no definition of material breach. AL, is there a definition of repudiatory breach? Well, I can actually help you on that one. There is an abundance of definitions of repudiatory breach, and the judges have never settled on one definition of repudiatory breach. And in the Valilis and Yanuazai case, I think it was Lady Justice Arden who mused, saying it's probably a good thing that the law has so many definitions of repudiatory breach, so that it's a flexible test that can be applied in all sorts of different circumstances. Yeah, thanks, Shavana. You too. So repudiatory breach is desperately serious. It's been defined as a breach that goes to the root of the contract, or which deprives one party of substantially the whole benefit it was anticipated he would receive from the contract. Loads and loads of definitions, loads and loads of definitions. But the one thing we do know is that repudiatory breach is a more severe, it's a more stringent, more exacting test than just a material breach. It's just that we don't know where material breach is. Yeah, I know, Jim. God, I'd rather be. I sort of look at this photograph and weep, really. I mean, I should be standing next Thursday. I should be standing exactly here in the warmth in the evening, and I should be sipping my Singapore sling in exactly this spot in Bangkok. Whether I will is a different question. Yeah, as I say, I'm not sure who AL is, but what I want to do is an occasional series on like standard clauses, standard expressions you see in contracts, boilerplate things. So yeah, I might well be looking at termination sometime in the future, looking at different aspects of it. Yeah, absolutely, I might. Any more? Yeah, okay, so I think people now drifting away. I don't think any questions. So I'm going to wish you all, as I say, Happy Christmas if you celebrate it. Happy holidays if you don't. If I don't get to Bangkok, I will be sitting in this room weeping buckets, I should think. I might have a Singapore sling anyway, but I don't think I'll ever get over the shock. No holiday since 2019, August 2019. It's not good for a man. But anyway, okay, I'm going to shut down now. Thanks to everyone. Speak soon. Keep safe. Keep well. Hope to see as many of you as possible in the new year. Okay, bye-bye.